Good morning, Ms. Jackson.
Good morning, Your Honor.
How have you been?
Good. How are you?
I'm hanging in there. Can you share criminal history information, please, on Mr. Sherman?
Yes, sir. There are 23 cycles. The last arrest was April the 12th, 2016, with the City of Atlanta Police Department for possession of marijuana less than an ounce. There was no disposition for that arrest. He does have prior felony convictions. One in 2006 for aggravated assault and possession of a firearm during commission of a felony. One in 2005 for possession of controlled substance. One in 2003 for false imprisonment and theft by taking. One in 2002 for possession of marijuana with the intent to distribute. And one in 2000 for possession of controlled substance. He does have misdemeanor convictions. One in 2010 for simple battery, family violence, and criminal trespassing. One in 2004 for giving false information to an officer and tampering with evidence. Nothing in addition.
Thank you. Ms. Wood.
Judge, do you want me to go ahead and tell you what I'm going to be asking for?
You might as well get it on the record so Mr. Sherman hears it and knows it's on the record and you've planted that poll. And then I'll let Ms. Davis wait so she's had a chance to talk to Mr. Green and Mr. Marshall and get their thoughts.
Perfect. Judge, as you know, I generally do not have clients enter pleas at arraignment to such serious charges. However, Mr. Sherman has been adamant that he was eager to resolve. And so I've told him, I don't have full discovery here. I'm very limited in what I can say about the strength of the state's case at this time, but here we are. And so that's why I was pushing to let us plead today. Judge, he's 43 years old. He's a lifelong resident of Atlanta. He's a Crawford Long baby, not a Grady baby. All of his family's here. He has 4 children, ages 15, 16, 20, and 23. He has a 10th grade education. He was working at Clark Atlanta University in the kitchen. However, he did get injured, and so he was in the process of working on getting disability benefits when these incidents happened last year. Judge, he's been in custody since the last arrest, so he's been in, I think it's 382 days. Prior to these 2 incidents that were so close in time and close in location, he had not been arrested since 2016. One of the cases he maintains would have been, there would have been an argument of self-defense. There was, of course, something else to the story that we don't quite know everything that was transpiring, Judge. I do just want to point out from the warrants, it sounds like both victims were able to get away. I didn't hear any mention of medical treatment, even though they were both shot. He's asking the court to consider a sentence of 10 serve 1, Judge.
Got it. Okay. All right. Mr. Sherman, I do find that there's a factual basis for your pleas in both cases. If the state was able to prove up what Ms. Davis just said, a jury could find you guilty of aggravated assault. It sounds like in one and maybe both cases, there are some potential defenses of self-defense or who knows, mistaken identity, but sounds like a jury would see video evidence. And in particular, if Mr. Green and Mr. Marshall were to testify, they might be able to say, that's the guy who did it. That's not me saying that trial would go poorly for you. It's me saying a jury could convict you, and so I can accept your guilty plea. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea. And I know that's true here. You are saying, let's do this. And knowing means you've understood all the things we discussed. Do you have any questions about anything? Okay. Then I will accept your guilty plea in both cases. I will defer sentencing to give the state a little opportunity to track down, if they are able, both Mr. Green and Mr. Marshall, and then we'll reconvene. And as I told you before, if in the end the sentence that I impose is more severe than 10 years to serve 1 year, you'll have the ability to withdraw your plea. It won't be automatic, meaning I'll ask you and Ms. Wood to talk about it, because maybe I'll say 10 years to serve 1 year and 1 day. Anyway, you know what? I'll do that. In fact, you've already done 1 year and a day. That would be dumb for me to change it. Basically, Ms. Wood has asked for a time-served sentence. But if I sentence you to more than that, you'll have the opportunity to consider it and then either reject it, you're not going to hurt my feelings, then we just move towards trial, or accept it and say, I would have liked less, but I don't really want to go to trial. I don't think that'll end so well for me. And then we'd handle it that way. So I will get you brought back here once we're in a position to do the rest of the sentencing. I'm going to ask it now. Ms. Wood, do you authorize someone on my staff to sign the 2 indictments on your behalf?
Yes, Judge.
Ms. Davis, can we sign for you?
Yes, Judge, but I did put off. Do you want me to sign it?
Oh, wow, look at that. We'll talk about that afterwards. Mr. Sherman, if we go forward with the sentencing, is it okay if we electronically sign your name to the indictments indicating your 2 guilty pleas?
Yes.
Okay, all right. Then we're gonna pause now. We've gotten as far as we can. And then we'll reconvene in a few days to talk about the state's recommendation. And then assuming that recommendation is not 10 to serve 1, what I'm gonna do about the sentence, okay? Thank you, everyone.
Thank you, Judge.
All right, we are done with this morning's calendar. Ms. Jackson, we are not going to start up until 1:30, not at 1. We have one calendar that's published for 1, but I have a meeting that's going to go 12:30 to 1:30. So we're keeping the Zoom?
Yes.
Okay, so the Zoom will stay up. You're welcome to stay on it, but we won't reactivate until 1:30.
Thank you, Judge. I'll see you then.
You bet. All right, I will mute that.
Well, that took a turn. This hearing offered an unexpectedly candid and layered look at a guilty plea in progress, and it's not every day you see a defendant pushing harder for resolution than even the defense attorney. We're back with Mr. Winfred Sherman, the same defendant from the earlier plea, and this segment dives deeper into the sentencing phase of 2 aggravated assault and firearm possession cases. And what stood out immediately was the judge's blend of professionalism, patience, and just a hint of dry wit. She was in full command of the process, laying out the stakes without ever losing that touch of courtroom humanity. You could tell she's done this a few hundred times and still respects every one of them. The hearing kicked off with a criminal history rundown that was long. 23 cycles, going all the way back to 2000. The record included several felonies, including aggravated assault, possession of a controlled substance, false imprisonment, and firearm possession during a felony. There were also a few misdemeanors sprinkled in, including simple battery and tampering with evidence. So this wasn't Mr. Sherman's first dance in the justice system. That said, his attorney, Ms. Wood, made a passionate and grounded case on his behalf. She emphasized that he hadn't been arrested since 2016 before these 2 2024 incidents and noted his strong Atlanta ties, his family, and his work history. He'd been employed in the kitchen at Clark Atlanta University until an injury sidelined him. She also highlighted that both shooting victims survived and that, from the available information, there were no confirmed medical treatments. That subtle but important point was part of her push for a 10 years to serve 1 sentence, essentially asking for time served with probation to follow. Interestingly, it was Mr. Sherman himself who had been urging this plea all along. Miss Wood acknowledged that she normally wouldn't recommend pleading at arraignment for such serious charges without full discovery, but her client was adamant. That raised eyebrows in a good way. The judge took note of that. Touche made it clear the plea was knowing and voluntary and praised Sherman for taking initiative while still preserving the option to withdraw if the sentence exceeds what's been requested. The prosecution, meanwhile, didn't push back immediately. Ms. Davis was asked to follow up with the victims to get their perspectives before any final sentencing decision was made. The courtroom vibe? Surprisingly collaborative. Everyone from the judge to both attorneys seemed to want to get it right. The judge explained that if she ultimately handed down a stiffer sentence than 10 to serve 1, Mr. Sherman would get the chance to withdraw his plea and go to trial if he wanted. She even joked that if she added just 1 extra day to the sentence, he'd already served that much, so it wouldn't make sense to start over. That kind of practical empathy is rare to see in court dialogue. At the end, we pause sentencing is still pending. But one thing's clear, this wasn't a rubber-stamped plea deal. It was a careful balancing act between public safety, rehabilitation, and personal accountability. And in a courtroom that could have leaned cold or procedural, the human element stayed front and center. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.